A will is not simply a legal document. In a family like this one, it is the last private statement a person makes about what they valued, what they feared, and who they trusted when they could no longer speak for themselves. Prince William had not expected to be summoned to Windsor on a Thursday morning with no explanation beyond the phrase, "urgent private matter." He had learned, across the years of his adult life inside the monarchy, to read the institutional signals that accompanied that kind of summons, the particular tone of a private secretary's message, the care taken to indicate that no public preparation was required, the absence of any briefing notes in the accompanying materials. He had read those signals and arrived at Windsor understanding that what was waiting for him was personal rather than constitutional. He had not understood how personal until the document was placed before him. Inside a sealed administrative folder held within the palace's succession planning records, a protected archive, the formal collection where documents relating to the monarch's private estate and inheritance arrangements are preserved and managed, palace legal officials had discovered a set of amendments to the royal will that had been made and authenticated in the months following Charles's coronation. The amendments were legal. They were properly witnessed. They carried Charles's personal authorization on every page. What they also carried, what had sent the palace's chief legal advisor to William's office before the morning was fully underway, was a set of changes whose implications for William's role, his household's future, and his understanding of what Charles had privately decided about the transition ahead were significant enough that the advisor had concluded the future king could not be allowed to encounter them for the first time without warning. When William finished reading and set the document down with the particular stillness of someone whose entire framework for understanding a situation has just been rearranged, those present in the Windsor reading room have described the silence that followed as the kind that asks nothing of the people inside it and receives nothing in return. He sat in it for a long time. Before we go deeper into what this really means for the royal family, make sure to subscribe so you don't miss a single update. The palace's succession planning records were maintained by a small team of senior legal officials who operated with a degree of institutional separation from the broader household administration, a separation that existed by design, to ensure that documents of the most sensitive character were handled by people whose professional obligations ran to the integrity of the records themselves, rather than to the political and communications considerations that governed other parts of the household's work. The discovery had occurred during what those officials described, in the account that has since emerged from people close to the process, as a routine authentication review, a periodic examination of recent additions to the succession planning archive to confirm that all documents had been properly executed, witnessed, and classified. The amendments to the royal will had been added to the archive several months earlier. Their authentication was not in question. What the reviewing official had flagged was a discrepancy between the amendment's classification designation and the access protocols that governed which members of the household's legal structure were automatically notified when documents of that character entered the archive. The will amendments had been classified in a way that placed them within the senior legal team's access, but outside the automatic notification list for the Prince of Wales's legal advisors. This was not unprecedented. The royal will was a private document, and the king's arrangements for its management were his own. But the specific content of the amendments, once the reviewing official had read them and understood their scope, had presented a question of professional obligation that the official had taken immediately to the chief legal advisor rather than resolving alone. The chief legal advisor had read the amendments. He had considered his position for a period that those who knew him well described as short and decisive, and he had gone to William's private secretary before 9 o'clock. William had arrived at Windsor by mid-morning to find Catherine already there. She had been reached separately, at the advisor's quiet insistence, because the advisor had understood from his reading of the amendments that this was not a matter William should encounter alone. Catherine had read the document summary the advisor had prepared before William arrived. She had not told William what it contained when he walked in. She had simply stood when he entered and stayed close. The document itself was placed before him by the chief legal advisor, who had offered to summarize its contents first. William had asked for the original. He had read it himself, from the first page to the last, without interruption. A royal will amendment, in the formal terms used by the palace's succession planning structure, is a legally binding modification to the existing testamentary arrangements governing the distribution of the sovereign's private estate, the personal assets, properties, and holdings that belong to the monarch as an individual rather than to the crown as an institution. Such amendments require formal legal execution, independent witness authentication, and registration within the succession planning archive. Charles's amendments met all of those requirements. They had been prepared by the king's personal legal advisors, witnessed by 2 independent legal officials, and registered in the archive under the king's personal authorization. What they described was a set of changes to the existing arrangements that affected, directly and materially, the terms under which several elements of Charles's private estate would pass to William at the time of Charles's death. 3 specific changes were of particular significance. The first concerned a collection of private royal residences that had been understood, within the family and among the household legal staff familiar with the previous arrangements, to be designated for William's household. The amended terms introduced a set of conditions on that designation. Conditions whose practical effect was to require William to maintain certain properties in a manner and for a purpose that the amendments specified, rather than allowing William's household to determine their use independently. The second concerned a set of private financial holdings. The amended terms introduced a trust structure, a legal arrangement in which assets are held and managed by appointed trustees rather than transferred directly, that interposed a layer of trustee oversight between William and direct access to those holdings for a defined period following Charles's death. The trust's terms gave the trustees, who were appointed by Charles rather than by William, significant discretionary authority over the pace and conditions of distribution. The third was the one that had sent the chief legal advisor to William's office without waiting for a scheduled appointment. The amended terms introduced a private memorandum, a formal written statement attached to but separate from the will itself, that set out Charles's personal wishes regarding the future of a specific set of arrangements between the royal household and several long-standing institutional relationships. The memorandum was not legally binding in the way the will's other provisions were, but it was clearly intended to carry the weight of Charles's expressed wishes, and its existence, its presence in the will structure as a formal document, meant that William would receive it as part of his inheritance and would be expected, within the family's own understanding of what such memoranda meant, to take its contents seriously. William had read all 3 sections twice. Then he had set the document down and looked at the window. Catherine had said nothing. She had watched him read. When he set the document down, she had placed one hand on the table beside his without touching him, the gesture she used when she wanted him to know she was present without adding to what he was already holding. He had sat with that for a long time before he spoke. William had understood, from the earliest years of his adult life, that the monarchy's private and institutional dimensions were not always easy to hold apart. He had grown up watching his father navigate the space between Charles the man and Charles the heir, and he had absorbed, through observation rather than instruction, the particular skill required to carry a private self inside a public role without losing either to the other. What he had not fully accounted for, what the amendments now sitting on the table in front of him had made impossible to avoid accounting for, was the possibility that Charles had made significant decisions about William's future in a private legal process without any direct conversation with William about what those decisions reflected or why they had been made. The trust structure in particular, had landed with a weight that those close to William have described as landing differently from the other changes. A trust interposing trustee oversight between William and direct access to financial holdings, with trustees appointed by Charles, with discretionary terms set by Charles, meant that even after Charles was gone, Charles's judgment about the management of those holdings would continue to operate through the structure he had designed. William would inherit not simply assets but conditions. Not simply a future but a set of constraints on how that future could be shaped. Charles received word that William had read the document through a brief communication from the chief legal advisor, who had discharged his professional obligation by ensuring that the future king had been informed and was seeking a private meeting with the monarch as a matter of some urgency. The communication did not characterize William's response. It did not need to. Those who have come to understand Charles's manner in moments of genuine institutional pressure have described his response to the advisor's communication as the particular stillness of a man who has been anticipating a specific conversation and now understands that its timing has been taken out of his hands. He had asked for the private meeting to be arranged for that afternoon. He had asked that no advisors be present on either side. Catherine had asked William, after the chief legal advisor had stepped out of the reading room, one question. Had any of this been discussed between him and Charles? Any part of it? The conditions on the residences, the trust structure, the memorandum? William said, no. She said, none of it? He said, none of it. Not the existence of the review, not the intent behind the changes, not the question of whether these were matters he thought I should have been part of deciding. Catherine said, then that is the conversation. William said, yes, that is exactly the conversation. The room Charles used was the same small private sitting room that had hosted the most difficult family conversations of his reign. He was already inside when William arrived, seated in the chair he used when he wanted the conversation to feel personal rather than institutional, not behind a desk, not at a table, but in the particular configuration of a man who has placed himself where he cannot easily manage the distance between himself and the person he is about to speak with. William came in and sat across from him. He did not bring the document. He had it fully in mind. He did not need the paper in the room to say what he had come to say. He asked his father one question. Had Charles understood, when he made these changes, that William did not know they were being made? Charles said, yes, I knew. William said, and you chose not to tell me. Charles said, I found the conversation difficult to begin. I allowed the legal process to move forward while I was still working out how to begin it. And then the process was concluded, and the document was registered, and the gap between the moment of telling you and the moment of the document's existence became something I continued to push forward rather than close. William said, for several months. Charles said, yes. William said, I want to understand the trust structure. The trustees you appointed are not people I would have chosen. The discretionary terms they hold are not terms I would have agreed to, and the effect of the arrangement is that after you are gone, decisions about how those holdings are managed will be shaped by your judgment about what is appropriate rather than by mine. Charles said, that is an accurate description of what the structure does, yes. William said, I would like to understand what judgment led you to conclude that was appropriate. Charles was quiet for a moment. Then he said something that those who have come to understand the substance of that conversation have described as the admission that required the most from him. He said that the trust structure reflected, more honestly than he had managed to say directly, a set of concerns he had carried about the pace and character of certain aspects of the transition, concerns he had found himself unable to raise in direct conversation with William, and which had therefore found their way into the legal structure instead. William said, you designed a legal arrangement to carry concerns you did not feel able to raise directly with me. Charles said, yes, I am aware of how that sounds. William said, It sounds like a decision made by someone who trusted the law more than he trusted the conversation. Charles did not answer. The room was quiet for long enough that it became its own kind of answer. William said, "I am not asking you to withdraw the amendments tonight. I am asking you to tell me, directly and completely, what the concerns are that produced them. Because if there are things you believe I need to understand about how you see the transition ahead, I would rather understand them from you than discover them in a legal structure after you are gone." Charles said, "That is a fair thing to ask." He said it with the quality of a man who had known for some time that it was fair and had been choosing, until this moment, not to act on that knowledge. Then he began to speak. And for the first time in the months since the amendments had been drafted, the concerns they contained were spoken aloud, rather than encoded in conditions and trustee discretions and memoranda, offered directly, by Charles to William, in a room with no advisors and no institutional language available to soften the shape of them. William listened without interrupting. When Charles finished, he asked several questions. Some of the answers were difficult. None of them were what he would have expected. All of them were more useful than anything the amendments themselves had contained. By the following morning, word of an unusual private legal consultation involving the palace's succession planning records and the Prince of Wales's legal advisors had reached the journalists who covered the royal family with sufficient regularity to know when the absence of information was itself significant. The palace had issued no statement. That silence, in the careful reading of those who understood how the household communicated about sensitive matters, was read not as denial, but as an institution managing the gap between something having occurred and a decision being made about how to describe it. Outside Buckingham Palace, a small group had gathered by mid-morning. No organized presence, the spontaneous kind that arrives when people sense that something significant is happening behind closed doors, and feel, without being able to fully articulate why, that it concerns them. One man stood near the front holding a handwritten sign that read, "The next king deserves to know." A camera found him within the hour. The image appeared on a front page before the afternoon edition was finalized. A national broadcaster described the situation that evening with characteristic care. There were indications that the king had made recent amendments to his private testamentary arrangements, and that the Prince of Wales had sought an urgent private meeting with the monarch in connection with those amendments. The broadcaster did not characterize the content of the amendments or the nature of the conversation. It left the question that the public was now asking in its plainest form. What had Charles decided, and why had it required an urgent private meeting to discuss? What the king decided, what the heir didn't know. The headline ran above a photograph of Charles and William at a formal public engagement from the previous month, standing side by side, composed, their expressions carrying the particular quality of two people who are accustomed to being photographed together and have long since learned to hold themselves in the frame without revealing anything the frame was not meant to show. Charles released a formal statement by late afternoon. It confirmed that the king had recently completed a review of his private testamentary arrangements as part of standard periodic estate planning, and that the Prince of Wales had been briefed fully on the nature and purpose of those arrangements. It confirmed that the king and the Prince of Wales had met privately to discuss the arrangements directly and had reached a clear mutual understanding of their basis and intention. It announced that the palace's protocols for notification of the heir apparent regarding significant private estate planning documents would be reviewed to ensure that future amendments were communicated directly rather than through the standard archive access process. The reform was specific. Its meaning was direct. What had happened? A future king reading material that described his own future through a document he had not been told existed would not happen again through a gap in notification procedure. William's spokesman released a single sentence. The Prince of Wales had met with the king and appreciated the direct conversation that had taken place. William returned to his own study that evening, carrying something that those who knew him well would have recognized as the particular quality of a man who has absorbed a significant thing and is still in the process of deciding what it means for him, rather than what it means institutionally. Catherine found him there. She had managed the household's communications through the day with the efficiency and discretion that those who worked alongside her trusted completely, and she had ensured that the story's public dimensions had been handled without adding fuel to what was already burning at its own pace. She sat beside him. He told her what Charles had said in the private room. Not all of it, because some of it was still settling, but enough. The concerns, the difficulty Charles had found in raising them directly, the way the legal structure had been designed to carry what the conversation had not yet been brave enough to hold. Catherine listened. When he finished, she asked, "Do you believe the concerns were real?" William said, "Yes. Some of them I had been carrying myself without naming them. Some of them were things I had not fully considered. All of them were worth knowing." She said, "And the trust structure?" He said, "We will discuss that separately, with advisors, when both of us have had time to think about it properly. That is a different kind of conversation from the one we had today." She said, "But today's conversation was necessary." He said, "Yes, it was the one that should have happened months ago, before any of the rest of it." She said, "He knows that." He said, "Yes, he knows it now." They sat together in the quiet of the study for a while. The public dimension of the day was behind them. What remained was the personal dimension, the longer consideration of what it meant to discover that a person you trusted had been carrying concerns about your future in a legal document rather than in a direct conversation, and what it required of both of you to move forward from that discovery honestly. William had not received the answer he would have designed. He had received something less convenient and more useful, a direct account of what Charles had been thinking, uncoded by legal language, unfiltered by institutional management, given in a room where neither of them had the protection of an advisor to soften what was being said. That was what he had asked for. It was what he had received. The amendments remained in the succession planning archive. Their terms had not been withdrawn. What had changed was the context in which they sat, the conversation that now existed alongside them, which meant they were no longer evidence of a private judgment made in silence, but the starting point of a discussion that both men were now equipped to have properly. Charles had made changes to his will in private and had not told William. That was a failure of the directness that their relationship required, and Charles had said so in the plainest terms available to him. William had read the document, had sought the direct conversation, rather than allowing the institution to manage the distance between them, and had come away understanding his father's concerns in a way the document alone could never have produced. What the hidden will changes had ultimately revealed was not a rupture or a betrayal. It had revealed the particular difficulty of a father and son who were also a monarch and his heir, two people whose love for each other and whose institutional responsibilities toward each other were sometimes the same thing, and sometimes, at the edges, very different things, and who were still, in the account of those who knew them best, learning to tell the difference. The conversation had begun. It had been a long time coming. They were better equipped, now that it had happened, to continue it honestly. Thanks for watching. Please don't forget to like and subscribe, and we will see you in next.